Now, let's move on. And candidates eyeing the LSK presidential seat have vowed to pursue the obedience of court orders by the executive arm of government should they be elected to the position. The candidates, however, differed with President Uhuru Kenyatta on his position that legally practicing elected leaders should be barred from representing clients in court. The president maintains that it is a conflict of interest for the elected leaders to litigate in courts of law. Alan Ochanda has the report.
Law Society of Kenya has for a long time been blamed for its alleged silence when court orders are disobeyed by the executive arm of the government. As the LSK heads to the polls to change its apex leadership on 27th of this month, various candidates seeking to clinch the top position have vowed to ensure that the script is rewritten. On 12th December last year, during Jamhuri Day celebrations, President Uhuru Kenyatta took issue with elected leaders who are primarily advocates of the High Court, clashing with their primary oversight mandate as legislators. Case in point is when some senators represented Nairobi County Governor Mike Sonko in court. Nelson Harvey, Charles Kanjama, Harriet Chigai, and Maria Mbeneka, who have come out to battle for the LSK top seat, have, however, come to the defense of their colleagues.
We have processes on how you can recuse yourself within the court process, and you can apply. The other parties can apply, claiming that there's conflict, and if indeed the conflict is detected, you recuse yourself.
And I think if there is conflict of interest, the senator must choose. Either if he represents the client in court, then he cannot engage in matters touching on that governor, in the Senate. And if they choose to exercise their duty in the Senate, then maybe they should avoid representing the person in court. So they have to make a choice.
In recent years, the Kenya School of Law has been on the spot over massive failure of bar examinations. The contestants confessing it is a worrying trend which must be looked into lest advocate standards dwindle.
So we need, first of all, to look at how this training is offered, whether it is actually suitable for these candidates when they come out of the university into the School of Law, and whether it is suited to the kind of practice that they get when they get out here. So the KSL is not a training ground per se for lawyers. It is a training ground for an advocate. So that, I think, is the disconnect.
The LSK has a sway in the Judicial Service Commission by virtue of its two representatives, one male and one female. Its president is tasked with guiding the society in securing the rule of law, but some members feel that has not been achieved in the past and call on those seeking the position to alter the face of the society.
What I see going to happen in the very near future from next month is a Law Society of Kenya, a Council of the Law Society of Kenya that is going to champion for more funding to the judiciary. Today we are talking about funding of 0.6% of the existing budget. That is a slap in the wrist. What we need as a country is funding to the tune of 2.5% of the 3 trillion budget.
The society has a membership of 17,000 currently under the stewardship of Alan Gishuhi. Alan Ochanda, KTN News.